This is Barry Zalma on insurance. I'm an attorney who's retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about some exclusions for liability insurance policies. First, let's talk about assault and battery. Insurance against the liability that comes from an intentional tort is said to be against public policy. Insurance companies are generally forbidden to write liability insurance promising protection against the consequences of an intentional tort, since such activity would encourage intentional torts. Assault or battery, by definition, are intentional torts that should not be insured. An assault is defined as, quote, an intentional, unlawful offer of corporal injury to another by force, or force unlawfully directed towards a person of another under such circumstances as create well-founded fear of imminent peril, coupled with apparent present ability to execute, attempt, if not prevented. This is Black's Law Dictionary and from 1957, the deluxe 4th edition. Note that an assault requires no touching, no harm, just fear. Battery differs from assault only in that the present ability is carried out, and there is an actual, unwarranted touching that causes a corporal injury to another. You hit somebody in the nose and break it, you've caused an injury, and that is a battery. You threaten to punch him in the nose, and it looks like you have the ability and could do so, and he fears having his nose broken. That's an assault. Insurance involves the transfer from the policyholder to the insurer of the risk of possible losses. It should never be available for losses that the policyholder knows, plans, intends, or is aware are substantially certain to occur. The standard occurrence definition in every liability policy excludes coverage for injury expected or intended by the insured and incorporates the fundamental concept that fortuitous loss is a prerequisite for coverage. When the assault or battery is of a sexual nature or to a minor, there is never a question that it is unwarranted and unlawful, and not something that can be protected by a liability insurance policy. Assaults, given their intentional nature, would seem never to constitute an occurrence under a general liability policy. However, courts have taken or adopted two divergent positions as to from whose perspective the assault is to be viewed in determining whether it constitutes an accident. A result, though unexpected, is not an accident. The means or cause must be accidental. One treatise provides that the vast majority of decisions have held that intentional conduct can constitute an accident if the insured did not intend or expect to cause injury. Under California law, the word accident in the coverage clause of a liability policy refers to the conduct of the insured for which liability is sought to be imposed on the insured. This view is consistent with the purpose of liability insurance. Liability insurance is a contract between the insured and the insurance company to provide the insured in return for the payment of premium, protection against liability for risks that are within the scope of the policy's coverage. There is no potential for coverage under the policy where an insured assaults or batters another, were acts done with the intent to cause injury, and where there is no allegation in the complaint that the acts themselves were merely shielding or the result of a reflex action. The injuries were not, as a matter of law, accidental, and consequently, an unreasonable belief that the insured is acting in self-defense is not sufficient to make the act of assault and battery an accident. In Ronald P Goose versus Lorette, a 2018 decision of the Louisiana Court of Appeal, coverage was refused, and the insured and the injured person sued the insurer seeking indemnity for injuries resulting from a battery because negligence was alleged in the suit. An altercation between Goose and Lorette resulted in the litigation, and he sued Lorette for injuries. According to the suit, Goose entered the customer showroom of Tiger Audio to speak with Lorette about wages owed to Goose's grandson. As Goose approached Lorette, who was standing behind a counter, Earl Lorette III came from behind the counter and violently assaulted and battered Goose, throwing him to the ground, causing severe injuries to his mind and body, including but not limited to a fractured hip, which rendered Goose bedridden and a permanent injury. Lorette and Tiger Auto filed a third-party demand against their general liability insurer, Montpelier U.S. Insurance Company, contending that Montpelier's policy covered the alleged liability of Lorette and Tiger Audio and obligated Montpelier to defend them in the litigation. Goose also amended his petition to assert a direct claim against Montpelier as the alleged liability insurer for Lorette and Tiger Audio. Montpelier filed a motion for summary judgment, seeking dismissal of all claims against it, relying in relevant part on a policy exclusion applicable to bodily injury arising out of assault and or battery. The trial court granted the motion. Montpelier relied in relevant part on the following exclusion added to the policy by an endorsement. Quote, assault and battery exclusion. This policy does not apply to bodily injury, personal injury, or property damage arising out of assault and or battery, or out of any act or omission in connection with the prevention or suppression of such acts, including the failure to warn, train, or supervise, whether caused by or at the instigation or direction of the insured, his employees, patrons, and or any other person. The uncontradicted evidence established Goose was injured during a physical altercation with Lorette. The only conflict in the evidence concerns who was the aggressor, Lorette or Goose. However, that factual issue is not material to the application of the exclusion, which applies to bodily injury arising out of assault and or battery caused by or at the instigation or direction of the insured, his employees, patrons, or any other person. The exclusion does not depend on the identity of the person who committed the assault or battery, but extends to acts committed by any person. The exclusion in this policy was, therefore, clear. The insurance does not apply to bodily injury arising out of an assault and battery, or out of any act or omission in connection with the prevention or suppression of an assault and battery. This is so regardless of who precipitated the incident, whether an employee or a customer or anyone else. There is a difference between the versions of plaintiff and the employee, but there is no issue of material fact. If plaintiff's version is believed, his injuries arose out of an assault and battery perpetrated by the employee. If the employee's version is believed, plaintiff's injuries arose out of the employee's attempt to prevent or suppress plaintiff's assault and battery on him. In either case, there can be no insurance coverage. Regardless of who was the aggressor, the evidence established that Goose's injuries arose out of either an assault or a battery. That undisputed fact alone makes the exclusion applicable. There is simply no coverage for the insured's potential liability resulting from a battery, whatever the theory or theories of law the tort claimant advances in a potential action against the insured. To find otherwise defies logic. The insurer who wishes to avoid the risks of loss by assault and or battery can do so as long as its exclusion is clear, unambiguous, and sufficiently broad to exclude any assault or battery by any person. This exclusion was sufficient, and it did not matter who hit whom, who was the aggressor, and who was the victim. There is no coverage for defense or indemnity to a claim where a person was injured during an assault or battery. Finding the assault and battery provision to be unambiguous, a Missouri court held that although the claim presented by the plaintiff was for negligence, because the claim still involved an assault and battery, the plain language of the policy still excluded the claim. Several other Missouri cases have also held that negligence actions arising out of an assault and battery are excluded by similar assault and battery exclusions. This was Pan Am Insurance versus the Bar, Inc., a 2006 decision of the Missouri Court of Appeal. In this case, the assault and battery is not incidental to plaintiff's negligence claims. The damages arise from the assault and battery. Without the underlying assault and battery, there could have and would have been no injury, and therefore no basis for plaintiff's action against the insured. The assault and battery and negligence are not mutually exclusive. Rather, the acts are related and interdependent. The insured's negligence, as found by the trial court, was not separate and non-excluded cause apart from the assault and battery. This is Adams versus Underwriters at Lloyd's of Missouri, a Court of Appeal case from 2019. This video was adapted from my book, Zelma on Insurance Claims, Part 102, second edition, which is one part of a 10-part treatise, Zelma on Insurance, all of which are available from Amazon.com as both Kindle books and paperbacks. If you found this video to be interesting or useful to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future videos and future blog postings. There are presently more than 200 videos at rumble.com. Thank you for your attention.